As discussed in our last decision, the record presented at that time showed that the agency had concerns about the activities of an individual identified as Mr. Y. The agency expressed interest in Mr. Y because of his former activities in connection with another contract named the EDUCATE Independent Verification and Validation Contract. The EDUCATE IV&V contract called for a concern named SD Technologies Incorporated to perform activities relating to determining whether DSFG was performing its contractual obligations under the EDUCATE contract, and whether the deliverables under that contract were acceptable. Mr. Y was the program manager for SD Tech during its performance of the EDUCATE IV&V contract. The agency's investigation identified certain non-public, competitively useful information that was available to Mr. Y in connection with performance of the EDUCATE IV&V contract. Despite this fact, the agency confined its OCI analysis and conclusion to considering whether Mr. Y shared DSFG's proprietary information with SRA, without considering whether the other information to which he had access also could have created an unequal access type OCI. In short, we sustained DSFG's last protest because the record did not show that the agency had given due consideration to the types of non-public information to which Mr. Y had access. In its current protest, DSFG principally maintains that the agency's execution of a waiver of SRA's alleged OCI was improper because it fails to set forth the extent of SRA's OCI, and therefore is deficient under the requirements for execution of a waiver outlined in Federal Acquisition Regulation, FAR, Section 9.503. The principal basis for DSFG's allegation is its position that the agency did not perform any further investigation into the activities of Mr. Y in the wake of our last decision, and therefore could not know the extent of the OCI presented by his participation in preparing the SRA quotation. We deny this aspect of DSFG's protest. Agencies properly may waive an OCI, provided that the waiver is executed in accordance with FAR Section 9.503, which states as follows. The agency head or a designee may waive any general rule or procedure of this subpart by determining that its application in a particular situation would not be in the government's interest. Any request for waiver must be in writing, shall set forth the extent of the conflict, and requires approval by the agency head or a designee. Agency heads shall not delegate waiver authority below the level of head of a contracting activity. While our office will review an agency's execution of an OCI waiver, our review is limited to consideration of whether the waiver complies with the requirements of the FAR, that is, whether it is in writing, sets forth the extent of the conflict, and is approved by the appropriate individual within the agency. Where a procurement decision such as whether an OCI should be waived is committed by statute or regulation to the discretion of agency officials, our office will not make an independent determination of the matter. Here, there is no issue regarding whether the waiver is in writing and was approved by the appropriate agency official. The only question, therefore, is whether the waiver sets forth the extent of any possible OCI on the part of SRA. We conclude that it does. As we noted in our prior decision, the contracting officer identified an array of information that had been available to Mr. Y during his participation in performing the EDUCATE IV&V contract, including DSFG proposals, submitted in connection with the EDUCATE contract, performance reports and other contractual artifacts. DSFG's EDUCATE solution to meeting the agency's information technology requirements, and reports that DSFG had marked confidential, sensitive and proprietary, and for official use only. The contracting officer also noted that Mr. Y had participated in inspecting DSFG's deliverables under the EDUCATE contract. The record shows that the contracting officer expressly identified precisely these types of information in describing any potential OCI when he executed the OCI waiver. Specifically, the waiver states as follows. From February 22, 2011 to May 26, 2016, Mr. Y worked as a project manager, a key personnel position, on the EDUCATE IV&V contract. In the course of that work, Mr. Y had full access to much non-public information not intended for use by competitors of DSFG and which would not have been learned by others outside the department. Mr. Y had full access to the following types of EDUCATE IV&V information and materials, among others. DSFG's proposals. Performance reports of DSFG on EDUCATE. Information regarding DSFG processes, procedures, resources, and controls. Deliverables from DSFG to the department and other contractual artifacts. Root cause analysis reports demonstrating sources of failed services rendered by DSFG. Internal discussions regarding DSFG's performance and associated materials reflecting such internal discussions. Mr. Y's IV&V work also included communicating extensively with a wide array of government officials regarding his independent findings/assessments of DSFG's services, as well as recommendations for considerations. The agency's OCI waiver goes on to recognize that the types of information available to Mr. Y would have been of interest to SRA, would have been useful to the firm in preparing its quotation for the IV&V requirement, and would have been helpful to Mr. Y in terms of informing any response to inquiries he addressed during preparation of the SRA quotation, even if Mr. Y did not directly share the information he had reviewed during the EDUCATE IV&V contract with SRA. The contracting officer concluded as follows: in short, the EDUCATE IV&V information learned by Mr. Y would have provided some advantage to SRA in preparing its IV&I proposal, even if not proprietary to DSFG or pivot source selection information. With that as background, the contracting officer found that any information gained by Mr. Y in connection with performance of the EDUCATE IV&V contract would have been limited in value because the nature of the pivot suite of acquisitions is fundamentally different than the EDUCATE contract. He concludes as follows. Based on the above, the conflicts that arise as a result of Mr. Y's access to EDUCATE IV&V contract information and his subsequent work for SRA's IV&I team are not deemed to be significant. Any resulting impact on the integrity of the IV&I procurement process, to include the solicitation itself, development of SRA's IV&I solution, and the source selection process or the resulting award, was not significant. In addition, the contracting officer went on to discuss 3 other potential OCIs arising in connection with the activities of other individuals that may have had access to other DSFG information that was the subject of our first decision in these cases. He concluded that any possible OCIs arising from the activities of these individuals also would be minimal in terms of competitive impact because the pivot and EDUCATE acquisitions were so different. We conclude that the agency's waiver decision took into consideration precisely the types of information that the contracting officer previously identified as a matter of concern during our last consideration of this protest. The agency's waiver also took into consideration several other concerns identified earlier in our first decision. Inasmuch as the agency's waiver sets out comprehensively the concerns that have been identified throughout our consideration of these protests, and in light of the fact that DSFG has not identified any other new concerns relating to any potential OCI that SRA may have, we conclude that the agency's OCI waiver here meets the requirements of FAR Section 9.503. We therefore deny this aspect of DSFG's protest.